Right, with a bit of luck, you now should have the presentation in front of you. You probably don't have my video on anymore, but you should be able to see that this is the welcome slide for for today's training. So we're looking at the effect of COVID-19, of the pandemic that we're currently experiencing, these extraordinary times, and we're looking at in the context of managing contractor performance during this current crisis, and in particular, looking at the force majeure clauses, which you will have come across. For those of you who don't know me, you can see my name there on the screen, Bill Blakemore. I used to practice as a barrister here in the UK, haven't done now for some time, but I do put my legal skills into use with training sessions like this. So just a little bit of background about me. When I qualified as a lawyer, I got experience of various kinds, including quite a lot in the area of contracts and commercial law. And I took that legal experience out of the legal profession into one of the UK's largest companies. I worked for British Telecom for about 18 years in a variety of different roles. Spent quite a bit of time working with customers, and that meant looking at a lot of contracts. I left BT now about 16 years ago, so I've been independent since then, and I've spent a lot of time working with people from the public sector and also the private sector, often looking at areas such as procurement and contract management. So if you're working for a state-owned company, perhaps in the petroleum industry or the energy sector, then I'm very familiar with the kind of world that you're living in and working in. I get to travel, or I usually get to travel a great deal with my job, often to the Middle East, sometimes to West Africa, and sometimes to other parts of the world. But right now, I'm not doing too much traveling at all. Having said that, I'm going to play you a short video before coming back to these slides and continuing with the presentation, just to give you my personal take on where we are right now with this extraordinary pandemic. Not everything happens as quickly as one would like. The video I'm about to play to you, it is on YouTube, but it's one I created over the weekend in preparation for today's session, because these are such extraordinary times that I thought I'd just give you my personal take on what's going on. Anyway, here we go with the short YouTube video. It's about 4 minutes long, this. April 19th, 2020, a Sunday, should be just like almost any other spring day in Britain. The sun is shining. I'm out in my garden. It's been a very pleasant day. And yet, these are not normal times. I'm sitting in my garden, and that's almost the only thing I'm allowed to do outside. I'm not allowed to travel anywhere. I'm not allowed to go for a trip up to London. And tomorrow, rather than going off to work, I'll be staying here, as I have done for the last month. That's the law. It's a lockdown. And it's a lockdown that afflicts the whole country, and indeed most countries in the world right now. Because, as you know, this is the way to deal with the COVID-19 global coronavirus pandemic. It's an unprecedented time. Everybody says so.
And what that means for contract performance is pretty serious. If you think about it, the trains aren't running, the planes aren't flying, the hotels are closed, business is shut, the global economy isn't functioning.
I spent a few moments on Saturday checking the webcams in major cities. Here's the one for Times Square in Manhattan, New York City. As you can see, it's completely dead. The Grand Canal in Venice was no better. Here we are, Saturday evening, and there's nobody to be seen. This is extraordinary. Whenever I've been to Rome, I've tried to visit the Trevi Fountain. It's a tourist hotspot, and you can't usually get close. Everybody throwing in their pennies into the fountain. King Charles III, sitting on his horse in central Madrid in the Puerta del Sol Square, seemed to have the place entirely to himself.
It does mean, of course, we have to be creative, using tools like this. But for many people, that's no longer an option. After all, in Britain, right now, more than 16,000 people have died from the coronavirus. Who knows how many that number will be by the time this awful tragedy is finished. Government responses to this pandemic have been extraordinary. Shutting down the country, issuing emergency legislation to stop businesses being open, to require people to adopt social distancing. I have to stay more than 2 meters apart from anybody else, apart from anybody living with me, such as my wife, in the same house. I am allowed to exercise once a day, and I can go to the shops. But if I do that, I'm expected to social distance, and of course, most of the shops are shut. Only the food shops are functioning. So there's no question that the legislative procedures that have been put in place have meant that many, many people are unable to work. Contracts are effectively being cancelled. And what we're going to be looking at today, after we've examined how things are throughout the world, is to think about what are the rules about procedures such as the legal concept of force majeure. How do they apply in a situation like this? I hope you enjoy the session.
Good. Let's get back to the presentation. Which I was showing you using screen sharing. Okay. So what's today all about then? Well, you'll have gathered from that introduction that we are looking at contracts and contract performance, and we're looking at it in the context of this extraordinary pandemic. It's an extraordinary time, and I don't think any of us who've practiced in the legal profession would have experienced anything even comparable with what's going on right now. As you saw in my intro video, it's not just, of course, the disease itself and its terrible consequences. It's also the effect of government action, which is taking place to try and stop the pandemic, which is leading to such a dislocation of business. By the way, a little health warning, and I use the word health advisedly here. Of course, I'm looking at contract performance and I'm looking at force majeure within the context of English law. That's what I qualified as an English lawyer. And the law may be a little different in your part of the world. The UAE, for example, and Saudi Arabia, you both have codes which are the basis of your laws. We have no such code process or code concept here in a common law country like the UK. So we're looking at precedent, case law, things of that nature, rather than a code-based definition of what force majeure is. So if while looking at this webinar, you're thinking, okay, is this giving me legal advice? Well, it isn't. It's really an information session to alert you to the concepts and the issues. But if you have legal advice that you need, please consult your legal advisors for that. Okay, so the agenda for today, now we've got the intros out of the way, are essentially a quick refresh on what contracts are all about, and thinking about contracts as a means of getting performance, and then also as a means of managing risk. We then move on to look out for what happens when you don't get the performance you want, and in particular, when you don't get it as a result of unexpected events. And that's really where force majeure comes in. We move on from that to look at the COVID-19 situation, where it is right now, and see how we can apply the principles of force majeure to COVID-19, as well as to find some way of planning for the future ahead. So the starting point, I guess, is to think about contracts. Now, maybe you learnt this concept, this Latin concept, if you studied law, the phrase pacta sunt servanda. It's a piece of Latin, and I'm sure some of you know how much lawyers like a little bit of Latin, especially early in the morning. Pacta sunt servanda. So what does that actually mean? Well, pacta, you can probably hear the word pact buried in the word pacta. Pact, agreements, sunt servanda, basically should be satisfied, should be kept. Agreements should be kept. It's an old Roman law principle, but it's been applied to treaties, it's been applied to other kinds of agreement, including contracts. So agreements should be kept. That's a fundamental, and that's why we put such store by the process of creating and making contracts and enforcing contracts. What are contracts? Well, of course, they are legal agreements between parties, usually just two parties. And they're setting out obligations of various kinds. You're making contracts, of course, to buy or deliver goods or services. You're looking for the provision of labor. Employment contracts are labor contracts of a kind, aren't they? Perhaps you're creating contracts to have a set of duties or obligations carried out, or you're looking as a means of gaining payment. If you're the contractor, you make the contract in order to get paid. So legal agreements between parties. Today, we're not going to look at what the necessary elements are to make legal agreements. We'll take that as read. But once you've got a legal agreement in place, of course, you do expect it to be kept. You expect it to be performed. And failure to perform is pretty obviously a breach of contract. Sometimes that's referred to as a default. And there are usually some consequences for contractual breach. Those consequences here in the UK could be a claim for damages. Damages, a form of compensation to the party that hasn't had the contracted benefit. Sometimes you put into a contract a liquidated damages clause, essentially a contract-based source of remedy for the party that hasn't had timely performance. It's another kind of consequence. Or you might have an opportunity for the innocent party, the party that's been injured by the non-performance, the right for termination to bring the contract to an end. There are different conditions may have to be satisfied before that right to terminate arises. Not every breach of contract necessarily leads to that right to terminate, but many serious ones do. And certainly if you're coming from the GCC region, you may have the opportunity to demand penalties, again, if you're the injured party. It's not something that, generally speaking, in a common law country, the courts will accept. Penalties are viewed as the province of the criminal legal domain, not the contract law. So don't write penalties into your contracts if you're working under English law. Anyway, that's what contracts are all about. And of course, contracts manage risk. We'll come to that in a moment. So what sort of performance we're looking to our contractors to provide? Well, here are some examples, of course. You're looking to them to do jobs properly. You don't want poor performance. You want that wall that you've ordered to be constructed, you want it to be in line with the specification, don't you? Not necessarily with the mortar hanging out from between the bricks like that one. Or maybe you want the guy who's going to be delivering your new color TV, perhaps the FedEx delivery agent. You don't want him to be throwing it over your fence when he delivers it. You probably want him to be bringing it to your door and at least knocking on the front door or ringing the bell, not just hurling it into your garden. Or if you're in the field of road construction, you want the pavements and the roads to stand up to the wear and tear they're going to get. So you want the job to be done properly. You also frequently want the job to be done in a timely way. Lateness is a common kind of failure in terms of contract performance. So late delivery, here delivery perhaps by Blakemore Wholesale. No relation, I should say. Blakemore Wholesale is a lorry company. Maybe sometimes they deliver late. Or perhaps you're catching a flight. Flights come late sometimes. That's actually a technical breach of contract. There may be some consequences for the airline company. And of course, if you're the contractor, you don't want late payment. You may be in a position to charge interest if the customer pays you late. So those would be alternative kinds of poor performance. Other areas of bad performance could include failing to comply with safety requirements, not applying environmental regulations, not getting a proper work permit for your staff, using people who are not qualified to do the job, perhaps even making corrupt payments. That is frequently a breach of contract, or abusing confidential information. So a variety of obligations here which can, in some cases, not be adhered to by one of the contracting parties, leading to some consequences which may be negative to the person who hasn't complied with the obligation. As I said just now, it's not just about performance of obligations that contracts are concerned with. It's all to do with the management of risk and the recognition that when you're making an agreement, there are risks that are inherent in the process, and those risks often need to be allocated to one side or the other. The best thing to do is to allocate them to the party that's in a position to manage the risks. So typical risk-related clauses in contracts would include things like an insurance clause, an obligation perhaps on the contractor to insure the job that he's doing, or to insure his people, workers' compensation insurance, things of that nature. There are indemnity clauses. Those pass the risk of a claim, very often a claim from a third party, from the party who's received the claim to the party who should pick up that liability. Perhaps that's the contractor. Maybe he's done the job wrongly. It's led to a claim against his client. The client wants to pass on that claim to the contractor. A liquidated damages clause, I mentioned that just now, contract-based remedy for late performance. Or a warranty clause. That's a kind of risk management clause, keeping the contractor on the hook after the contract is finished to make sure that if things go wrong in what he's perhaps constructed, he has to come back and make good the faults that have appeared within a period of time after the end of the contract. So those two are risk management clauses. And that really brings us on to force majeure, because force majeure is absolutely a risk management clause. And it is a contract-based remedy in force majeure. It's not something which exists outside of contracts. You have to include force majeure in your contract if you're going to try and take advantage of the protection that it brings, because essentially that's what force majeure does. It provides protection to a party that is unable to carry out some of its obligations. Perhaps it can't do them in a timely way, or maybe it can't do them at all. Usually there's been some kind of event preventing that. So the protection means that potential claims for breach of contract are not going to be upheld. The force majeure protection prevents the contractor picking up the normal liability that he would receive if he hadn't done things in the way or in the time that he should have done. Now, one of the interesting things about force majeure is each contract can define and apply force majeure in its own way. And it's absolutely vital that you read your contract when you're thinking about force majeure. There is no general force majeure clause which will apply in every case. Of course, there are templates and examples that you can borrow from different places, but these clauses are all a little different one from another. So it's important to look at what those differences are. Don't just leave it as a reference to force majeure. You may even find that if you did that, that the clause would be unenforceable because it would be too vague. There are too many variants. Okay, so here's a quick reference out to a contract which some of you may be familiar with. This is from what is referred to sometimes as the Red Book. It's a standard set of terms and conditions produced by FIDIC. FIDIC, of course, the Fédération Internationale des Ingénieurs de Consultants, Consulting Engineers Federation. It's a French body, in case you hadn't worked that out. And the Red Book is relating to terms and conditions where the employer, that's the contract owner, has done the design of the building. And I've just extracted a little piece from the Red Book, which should be on your screen right now, from clause 19.1, which defines force majeure. The clause actually runs to about six parts. So it's just the beginning I'm going to give you here. And by the way, this is from the 1999 version of these terms and conditions. The terms and conditions were revised again in 2017, but the changes were not very significant. So you can see here, we've got right at the beginning in this clause, force majeure means, so we have a definition here, an exceptional event or circumstance, which is, and then we go from A to D, beyond a party's control, which such party could not reasonably have provided against before entering into the contract, which having arisen, such party could not reasonably have avoided or overcome, and which is not substantially attributable to the other party. So we've got some prerequisites there. And after that is a little list of events which may fit your circumstance. And you can see here, it says force majeure may include, but is not limited to, exceptional events or circumstances of the kind listed below, so long as some other conditions are satisfied. And the events or circumstances listed include, you can see a little one here, war, hostilities, invasion, acts of foreign enemies, a little 2, rebellion, terrorism, revolution, civil war, little 3, riot, commotion, disorder, strike or lockout, and then by persons other than the contractor's personnel or other employees of the contractor and subcontractors. So there's a, if you like, a carve out there. We can have strikes, but not by the contractor's personnel or the subcontractor's personnel. Then you've got munitions of war, explosive material, similar things of that nature. And finally, natural catastrophes such as earthquake, hurricane, typhoon, or volcanic activity. Now notice, there's no reference there to COVID-19. There's no reference there to pandemic or epidemic. There's no reference to disease. They're not listed. However, because of the way this clause is drafted, force majeure may include but is not limited to exceptional events. We can probably get COVID-19 into the definition because of the way this is a set of examples rather than a definitive, limited, exhaustive list. So I would ask you to think about how is force majeure defined in your standard contracts? There are some general principles. I said it always is contract specific, but there are some general principles, and they work along the following lines, pretty much as we just saw exemplified there in that Red Book example. So force majeure usually depends upon the happening of an event, and that event is the sort of trigger for the claim for the protection. Without a triggering event, there's not going to be any opportunity to claim. And the event is usually got to be beyond the reasonable control of the parties. That's both parties. The party making the claim mustn't be at fault. He mustn't have caused the event. It mustn't be his fault. If you can point to him being at fault, then of course force majeure is going to a claim for force majeure is going to fall flat on its face. And this is absolutely vital, the event must prevent or delay the performance of the contractual obligation. So prevent or delay. Okay, so those are the kind of general principles that you'd expect to see. So if you were trying to conduct a piece of transportation on that piece of road that you can see illustrated there in the picture, well, maybe you wouldn't be able to pass by on that road, but could you claim force majeure if your journey was delayed? It would in part depend upon, was there an alternative route? Perhaps although the earthquake, the landslip, was not within the reasonable control of the parties, maybe it didn't actually prevent or delay the performance of the contract if there was another way to go. So not every bad event is necessarily going to lead to a claim. Okay, so what are some examples of trigger events? Well, we saw one or two in that Red Book case. Acts of God, earthquakes, hurricanes, and explosions. Other things like wars and rebellions. One that wasn't in the list from the Red Book is government action. Government action could be a decree, legislation, a new bylaw. It really depends upon the nature of your government to how new laws come into play. It could simply be a case of the king saying, you must not do something. Wouldn't apply in Britain. Her Majesty doesn't have that kind of power. But we have a legislative process usually governed by Parliament. So it's got to be a valid law, but that could in itself often be a source of force majeure. As it says at the bottom of this list, the list may be exhaustive or it may just be examples. And it's very important to work out what sort of list of events are you dealing with when you're looking at the contract. So let's have a look at another contract here. This one is from a 2018 contract from the oil industry. It's actually from the Logic General Conditions of Contract for Offshore Decommissioning. So this is the contract that's used for the scrappage of old oil rigs and other petroleum infrastructure in the North Sea. We've had an oil industry in Britain here since about 1980, and there's a lot of old stuff, old pipelines, old rigs sitting around on the bottom of the North Sea, and there's a requirement to get rid of those things. And the contracts that are very often used for this decommissioning work are based upon the Logic contract. So it's a recent contract, but in fact, the Logic suite of contracts have been around a long, long time. So this is the latest one in the series. And you can see here's our definition, and I'm going to highlight different words as we go through this particular definition. So you can see here, it starts off, neither party shall be responsible for any failure to fulfill any term or condition of the contract. So basically, it's talking about performance, failure to perform the contract, if and to the extent that fulfillment has been delayed or temporarily prevented. So we're talking about some time-related obstacle to performance. And for this prevention or delay to be by a force majeure occurrence as hereunder defined. So we know we're heading for a definition of what force majeure is. And the occurrence has to have been notified in accordance with the clause, and it must be beyond the control and without the fault or negligence of the party affected. So, as I said earlier, if you can say this is not an event without blame, you're at fault, you're the reason this event has happened, it will be difficult to make a successful force majeure claim in those circumstances. So beyond the control and without the fault or negligence of the party affected. Don't forget the notification, which is mentioned there too. Next, you're required to demonstrate that by the exercise of reasonable diligence, the affected party has been unable to provide against the event. So he shouldn't have taken protective steps. There's nothing he could have done to actually prevent the delay taking place, even using reasonable diligence. So that's our starting point. It's the basis of the force majeure claim in the logic decommissioning contract. Now, the definition moves on in section 15.2. And this is an interesting definition, and you might contrast it with what we saw in the Red Book, because here you've got this opening sentence: for the purposes of this contract, only the following occurrences shall be force majeure. So in this case, this is an exhaustive list. This is not one of those generous force majeure clauses where anything similar could be claimed as force majeure. You've got to be able to fit your event into this list of, I think it's 7 different headings. If you can't, then you're out of luck. You're not going to get the benefit of the force majeure protection. There's quite a lot in common, however, with the Red Book and the principles that we certainly saw before. So it starts off with things like riots, war, invasion, and terrorism, in little a. In little d, it talks about earthquake, flood, fire, explosion, and other natural physical occurrence. So those you might call acts of God, perhaps. But there's a carve out here, but excluding weather conditions as such, regardless of severity. Now, weather conditions could include some pretty awful storms, maybe even hurricanes, that would not fall into the force majeure definition because of this exclusion that's set out in the second part of little d. Now, why is that? Why have they done that? Well, they've done it because in the North Sea, where this work is going on, the weather is awful a lot of the time. The parties are expected to have prepared themselves for bad weather and not rely upon a force majeure claim to say, oh, I couldn't perform. I'm sorry, if you're going to do work in the North Sea, you're going to have to prepare yourself according to the schedule or the tools and equipment that you're using, prepare to operate in bad weather conditions. We've also got a clause about strikes, and you can see there's another exception: strikes or industrial labor not employed by the affected party, its subcontractors or suppliers. So strikes by your own team and your subcontractor's team are going to be excluded from a claim for force majeure. And at the end, we've got changes to any law or decree, any ordinance or statute. Now, this is interesting because, of course, again, in this definition, pandemics are not referred to. There's no reference to an epidemic, a plague, or anything of that nature. But if we think about what's going on right now, what's actually stopping contractors doing their work? It's possibly not the disease itself. Of course, maybe some of their workers are sick and they can't perform. But in more likelihood, the reason people can't perform is because they're not allowed to perform. The law has required them to stop working. And it's that kind of change of circumstance, the government intervention, which is really the basis upon which a force majeure claim could be lodged. We'll carry on. So here's another important thing to think about: the causal link. The force majeure event must be the cause of the non-performance, and it's got to be a tight link. If you find that there are multiple reasons for non-performance, of which a force majeure claim is one of them, then that's probably not good enough. It's got to be the only reason for the failure. Here's an example. A few years ago, Tullow Ghana, Tullow, of course, is a petroleum company operating substantially off the coast of West Africa. Tullow Ghana rented a drill, a drilling rig, and here it is. This is the Seadrill's West Leo semi-submersible drilling rig. So Tullow was renting this for $600,000 a day to drill off the coast of Ghana, which is where Ghana's petroleum is produced. And Tullow is a major producer. It's got a number of concessions in that offshore area. Now, at that time, there was a dispute between Ghana and its neighbor further to the west, which is Cote d'Ivoire. There was some argument about who owned the water in which this drilling was going on. And, you know, there are rules about the laws of the sea as to how far the territorial extent of a country extends out into the offshore areas. So there's this dispute, and the dispute went to arbitration under the laws of the sea. And as a result of that, there was an order from the arbitral tribunal for Ghana to stop drilling. And the government of Ghana told Tullow, you must comply with this order. You must stop drilling. Now, Tullow had intended to use this very expensive drilling rig in the field that was under dispute, the 10 field as it was referred to, but it also planned to use it in another field where it had some other rights, the Jubilee field, slightly further to the east. Unfortunately, it couldn't use the West Leo rig in the Jubilee field because their production and storage facility, the FPSO that they've got there, at that time, it needed some extensive repairs. And under the contract that Ghana government and Tullow had to get permission to spend a lot of money to repair this particular piece of equipment. Government of Ghana didn't give the permission, so Tullow couldn't use the FPSO to store the produced oil. As a consequence, it couldn't actually work in the Jubilee field. Now, as a consequence, Tullow didn't create a drilling program. Instead, it decided to terminate the hire contract, claiming force majeure. Seadrill were not happy with that. They were getting $600,000 a day for the hire of this rig, and there was a fee, a termination fee, set out in the contract of $270 million if Tullow terminated early, which is what they were purporting to do by claiming force majeure. Now, of course, Tullow didn't want to pay the termination fee. They said they weren't liable to do so, that force majeure had stopped them from being able to use the rig. It went to court, and the court found that, unfortunately for Tullow, because of the two reasons Tullow couldn't use this rig, one of which was force majeure, the tribunal ruling, and one of them which was not, which was the use of the rig in the Jubilee field, and the equipment there couldn't be used, and that was because of the government of Ghana's requirement that it couldn't be maintained, couldn't have money spent on it. That second reason was not within the force majeure definition, and as a consequence, with these two reasons, Tullow's claim for force majeure failed. They were held to be liable for the full amount of claim. They had also failed, it should be said, to use reasonable endeavors to find a way round the force majeure event. They had other options they could have done as well. There are other oil fields they could have used this rig with, and they should have thought about those too. So Tullow lost the case, very costly. Let's look at another case, again, of a losing claimant for force majeure. This one just came up in the Court of Appeal just last year, the classic maritime case, and it relates back to an accident in Brazil back in 2015. Now, we've got two parties here again, one of them a ship owner, classic maritime, and one of them a charterer, so a renter of the ship, a company called Limbungan Makpur, a Malaysian company. And the contract in question here was about getting the ship to carry iron ore from Brazil to Malaysia. And the ship owner was getting paid for that carriage contract. So it's a freight carriage agreement, a freight carriage contract. Now, near the mine where the iron ore pellets were coming from was a dam, the San Marco Mariana dam. And that dam was holding back what are called tailings, basically a kind of a huge lake full of waste and spoil materials that had come from the mine. And when that dam broke, the water just flooded out. It flooded all the way 415 miles down. It reached eventually the Atlantic Ocean. It killed 19 people in the process. It polluted all of the watercourses. It destroyed villages. It was an absolute catastrophe for the ultimate owners, which was BHP and Vale. They were the ultimate owners of the mine. Now, when the dam burst, production at the mine stopped. And as a consequence, Limbungan couldn't actually load the iron ore onto the ship. He couldn't get the iron ore shipments. Classic Maritime sued them, $20 million for the non-supply of the iron ore shipments. They wanted to be paid for the fact they'd made this vessel available for the shipping. And there was a clause in the contract which excludes liability in certain circumstances if one or other party failed to perform. Now, Limbungan claimed the protection of this clause. The reason that they hadn't supplied the iron ore and therefore were not liable, they said, to make the payments for the shipping. They lost the claim. And the reason they lost the claim was because the court said you wouldn't have complied with your contractual obligation anyway. So this is the way the clause went. You can see in red, it's on the screen. I hope you can read this. Neither the vessel nor her masters, owners, charterers, shippers, receivers shall be responsible for loss of damage to or failure to supply, load, discharge, or deliver the cargo resulting from. And then we've got a very long list of circumstances. So we've got acts of God, we've got floods, we've got epidemics and quarantine, we've got accidents at the mine or production facility, along with a whole load of other things. And there's also a catch-all, or any other causes beyond the owner's, charterers, shippers, or receivers' control. So there's our clause, which is a bit like a force majeure clause. The phrase isn't actually used, but it's just like a force majeure clause. So why did the claimant fail here? Well, it failed because it had a rather poor reputation in terms of performing under this contract, even before the dam had burst. And the court looked into the circumstances of its performance, and it said, even if the accident had not happened, we, on the balance of probabilities, feel you would not have provided the shipments. So it was a finding of fact that Limbungan would not have performed even without the dam. So this is called the but-for test. So if the result of of the force majeure, if it's but for that I would have performed, then you can claim. But in this particular case, the court felt that Limbungan would have failed anyway. They would have defaulted, and therefore they were liable. So interesting. And they ended up having to pay the full compensation to the ship owner. Okay, so moving on then to other aspects of force majeure, we're looking at really at a couple of instances. Are we looking at to see whether the trigger event, does it make performance impossible, or does it simply delay performance? One is less than the other, as you might imagine. It's a very high burden to prove that performance is absolutely impossible. There is no way round the event to allow me to perform the contract. It's not enough, if the clause requires the performance to be impossible, to say, oh, it's more difficult to perform it, it's more expensive to perform it, or I'll make a loss from the contract if I have to perform it. That's not good enough. So impossibility, a very high threshold, very high hurdle that the claimant would have to get over. If, on the other hand, he simply has to show that the event has hindered or delayed him, that's a lot easier. He may be entitled to an extension of time, or in some circumstances to additional money while he's trying to overcome the event, or until the event has passed. So there we have it. We're moving on to another obligation. You saw it perhaps in our example from the logic clause. the obligation to notify the counterparty about the event, to notify the party that's not affected that I'm suffering from an event which is preventing me performing. Now, this is all about communication. This is all about management, actually. You've got to notify the other side that I've got the force majeure event preventing me doing what I'm supposed to do under the contract. And the contract may be very specific about what notification is required. Perhaps there are details about when the notification has got to go ahead. Maybe it's very quickly, within 24 hours, say, of the event happening. Or perhaps you've got to provide good details of what you've tried to do to mitigate, or how the event stops the performance. What's my evidence? You may even have to keep reissuing the notice as circumstances change, if the event is over a period of time, to keep the counterparty informed. So, lots of details about notification. And if you don't get the notification right, if you're the claimant, you may find that you have failed to notify properly and that your force majeure protection doesn't arise. So watch out for that if you're a contractor claiming. Now, sometimes, of course, and we saw this in China, didn't we, a few months ago, the government or some government body comes out with a notice saying that it's a certificate saying we're declaring force majeure. Well, maybe that works under some areas of some jurisdictions in law, but it doesn't work in English law. There is no scope for this kind of certificate here. You've got to look at the contract. So our Chinese contractor can hold up his certificate for as much as he likes. You've really got to look at what does the contract say, and if it makes no reference to these declarations, they are to no effect. So a number of contractors, a number of suppliers will be looking at these right now thinking, well, that's not valid under my supply contract. Perhaps for LNG, for example. There are a lot of LNG contracts that suffered at the beginning of this process. The next area to think about is the duty to mitigate the loss, to mitigate the effect. If I can't go the route I was going to go, I have to go another way in order to find a way of delivering the transportation service I'm applied to do. So I've got to find a way around the problem. And sometimes that duty to mitigate can cost me money. We saw in the case of the Tullow and Seadrill litigation, Tullow didn't do enough to mitigate its loss. It just sat on its loss and said, oh, I'm going to cancel the contract. I can't use the drill. It could have used the drill in other places. So maybe the obligation is to use best endeavors. That's a very heavy obligation. Maybe it's to use all reasonable endeavors, slightly less, or just reasonable endeavors, that's less again. So these words have been much litigated over to determine, what are the different amounts of effort that a party has to make in order to demonstrate that it has tried to mitigate the effects of the event. In the Red Book, this duty to mitigate is phrased like this: each party shall at all times use all reasonable endeavors to minimize any delay in the performance of the contract as a result of force majeure. So this duty to mitigate is going to be there. And expect a challenge. If you're a claimant, expect a challenge. How did you try and mitigate? What's your evidence? What's your audit trail? Show the thinking that you put in place before you came up with the claim. How did you try and stop this hurting me as much as it has? Why didn't you do this or that? Why didn't you consider those things? The challenge is an area where the unaffected party is going to push back against claims for force majeure. So in the logic contract, here's our clause. It says, in the event of a force majeure occurrence, the party that is or may be delayed in performing. Of course, that is anticipating, isn't it? Anticipating there may be a problem. The problem hasn't actually happened yet in terms of our performance. Perhaps we can see the problem has happened, but our performance isn't due yet. But we may be delayed. So we are required to notify the other party without delay, giving the full particulars, and shall use all reasonable endeavors to remedy the situation without delay. So the notification and mitigation consequences. So what happens if you are able to make a successful claim? Well, of course, you're in luck. You're not going to be liable for your failure. Maybe there's a duty to renegotiate, or maybe the contract gets discharged. You always have to go back and read the contract. What is the consequence? It may even be that the contract is ended, although that's unusual. If it's an unsuccessful claim, well, you can expect litigation. You can expect legal action, perhaps damages, claims, termination, or penalties if you're working in the GCC. So high stakes if you don't get your claim right. The effects of a successful claim, you can see here from the logic contract, well, the schedule of key dates, but not the contract price, are adjusted. The parties have to meet to agree a mutual acceptable course of action, and then the contractor prepares a revised program when the event is over. So that's how it's addressed in the logic contract. Now, maybe you haven't put a force majeure contract clause in your contract. Perhaps you omitted to do so. Why would you do that? I don't know, but perhaps you did. So can you use some other kind of protection? There is a concept called frustration, contract frustration, which may be an alternative to you, but again, very difficult to get this one going. It's all about showing that the contract performance is impossible, which is why I've shown you a picture of from one of the Mission Impossible films, climbing up the Burj Khalifa tower. I'm sure you might remember that one. If there is no force majeure, frustration of the contract, but it's got to be an event so catastrophic it makes performance impossible, or it transforms it into something radically different. It's very hard to do that. We had some very old cases about the hire of a theatre, cases about the renting of a flat, cases about the purchase of a timber yard. In each case, something very massive happened. In the case of the theatre burnt down before the performances were supposed to take place. In the case of the renting of the flat, it was for a specific purpose, to view the coronation of King Edward VII. He got sick. The coronation procession didn't happen. That was enough to show that the purpose for which the flat was rented had become useless, had become frustrated. So not many modern examples. The most recent one I can come across was relating to something last year where the European Medicines Agency tried to claim its lease of its headquarters building in Docklands in London had been frustrated because of the possibility of Brexit. Brexit, of course, now having happened. It was a 25-year lease. The European Medicines Agency was not going to be able to stay in London if the UK left the EU. So it made a claim for frustration. The court rejected that claim. It said it could sublet the premises. That was a way to avoid the problem. And that's in fact what the Medicines Agency did. So their claim was unsuccessful. Can we claim frustration if there's already a force majeure clause? Well, that's very difficult to do because essentially you've given yourself a remedy, so you're unlikely probably to be able to fall back on the common law concept. Okay, so how does all of this apply to COVID-19? Well, of course, we are living in the most extraordinary times, aren't we? You know, the world is closed. There's London, there's Trafalgar Square with Nelson's column, and nothing going on, as we saw in some of those webcam videos in that introductory session. The virus has continued to grow in the most horrible way. 148,000 deaths by lunchtime on Sunday, 2.2 million cases. Daily death tolls are now at their peak, we believe, in many European countries, but that's still horribly high. That's a daily death toll of about 2,000 people in the United States. It's about 800 people here in the UK. The death toll has been absolutely catastrophic. Now, in response to that, governments locked down their countries. And you can see from this chart here that's changing in front of your eyes, various government actions of greater and greater strictness were put in place as time passed, as countries were locked down, making performance of contracts impossible. So over the weeks that this chart describes, as the colors get darker, the restrictions become more and more strict. So anything purple is very strict indeed. So it started in China, as you know, with these restrictions, and it moved to many parts of the world. So in terms of particular industries, well, that's the airline industry. That's the aircraft industry. If you look at that little map in blue on the right here, you can see as the little picture changes, the shrinkage in air traffic during the month of March. So airlines were closing. More than 100 airlines have shut down. And the flights tracked here on our map on the left here, our chart on the left here, you can see the average of total flights on a 7-day basis, looking back over 2016, 17, 18, 19, and 20. So each of these colors is a particular year until we get to 20. This is where the average of daily flights falls off a cliff. So the consequences of all of this, not just in airlines, but also sporting activities, of course. Many events have been cancelled or postponed, including the Tokyo Olympics, the Wimbledon tennis fortnight in June, the Grand National, Monaco Grand Prix, the Tour de France. So a whole variety of events have been cancelled. And they've been cancelled often because of legislation. Here we've got a little extract from the new laws that were passed on the 26th of March, so less than a month ago. This law was passed, the coronavirus restrictions regulations passed under the 1984 Public Health Control of Diseases Act, which requires certain premises to close completely. So that's restaurants, bingo halls, betting shops, nail bars, fitness gyms, swimming pools, fun fairs, car showrooms, and certain others can stay open. Food retailers, bicycle shops, funeral directors. So those restrictions are extraordinary, and they are probably the reason why most of our businesses have shut. So does any of this amount to force majeure? Well, remember, it's all about what's in the contract. What's in the definition? Is there an exhaustive list of trigger events? Is there instead a set of examples, plus perhaps a catch-all that sweeps up unspecified events? And what's the impact on performance of either the restrictions or the disease itself? Does it prevent or delay? Remember that delaying is a less high bar to overcome for the contractor. Is the event that we're talking about beyond the reasonable control of the parties? Well, the parties probably can't control the virus right now. But in future, as we go forward, you know, there are going to be controls that parties can put in place. They can find the PPE. They can vaccinate their people, we believe. We can get immunity, we hope. So perhaps there are things in the future where coronavirus happening will not necessarily be a force majeure event in the future. But remember, there's got to be a causal link between the event and the non-performance of the contract. And is the force majeure event the only reason? There's got to be notification. There's got to be mitigation if they can. So all of that's going to be in your contract. And if it isn't, you need to be thinking about revising your contract. So what are the lessons we need to learn? Well, I think we need to think that COVID-19 is not going away. Yeah, the lockdown will come to an end. Who knows quite how that will be, in stages perhaps, and at different paces in different countries. But we're going to have COVID-19 now. It's with us for forever. So it's the new normal. And it may be a long time till we get a vaccine. Who knows about immunity? We don't know enough yet. So we've got to plan for COVID-19 disruption in the future and maybe other pandemics as well. Governments may lock us down again. It's happened in China, I think this morning. Certain parts of China have become locked down again with a new outbreak. So what should you be doing? Well, I think you should be looking at your contracts right now, saying, do they fit? Are they fit for purpose for this new world of COVID-19? Should we be modifying them and then agreeing new wording for the future with our major contractors? And what burden is it reasonable to put on the contractor? And what burden should we take? Remember, the more you put on the contractor, the more expensive his contract may be. So think about your contracts, improve them, plan for the future, because the future is not going to be like it has been. And then I think the second thing you should do is think about your approach right now. There are an awful lot of contracts that are not being performed right now. Are you going to take a kind of competitive approach, trying to push the contractor back to take all of the cost, all of the burden? Or are you going to be collaborative? After all, some of these contractors are not going to be around. They will go out of business. So they need your support. They don't need to be beaten up. And ultimately, contract management is a relationship. It's not just about law and words in written agreements. So consider whether a collaborative approach to get over these unusual times is a better way. And also think about supply chains. A lot of us exist within a supply chain, and there may be the need for force majeure notices to be handed up or down that supply chain. Look at that linkage between the various performers in the chain. So what you do right now, the current situation may be different from how you approach in the future. In the future, I think we have the opportunity to plan and expect. Right now, not so much. Okay, so I'm approaching the end of the session. If you want more information on all of this, I have two places you might like to go to. A couple of law firms have done some really excellent work. The law firm Evershed Sutherland has written a guide to force majeure around the world, global. So you can find out their take on force majeure in the UAE, for example, or in Germany or France. They've done good analysis around force majeure from a different jurisdiction's point of view. And I rather like the work of Osborne Clarke, another law firm, with this heading, Coronavirus, Force Majeure, Supply Chains and Contractual Performance. If you do Google searches for both of those, you will find both of those cases. Okay, before we go, I'm going to be asking for questions in a second, and I'll move away from the presentation. There is a post-webinar test, so do make a note of this link here now. https:// and then it's bit.ly, so bit.ly/FM virus, all in uppercase. So if you go to that link, which is on your screen right now, and bit.ly/FM virus, it's a little 20 points test. You can find out, what did I get out of this webinar? How did I do? It will give you the answers straight away at the end of the thing. It also gives me some feedback on how well the webinar was for you. So thank you very much for listening. I hope you've enjoyed today. And if you've got questions, please put them in the chat box. I think we have time for a little bit of questions.